Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss a case law decided by the Honorable Supreme Court of India regarding the period of limitation in CRPC, that is Section 468 of the CRPC. Section 468 says, bar to taking of cognizance after the limitation period is over. You can refer to the case as Amit Lal Vs Shantilal Soni. Amit Lal Vs Shantilal Soni in Criminal Appeal number 301 by 2022 decided on 28/2/2022. Last year case. But anyway, important case. Normally, we are under the impression that according to Section 468, the magistrate will not take up the matter, cognizance of the matter after the period of limitation is over. So Section 469 CRPC says the commencement of the period of limitation. Here the tricky issue is there. So as regards the commencement of the period of limitation, number one, it starts from the date of offense. Very clear, from the date of offense. Second, when the date is not known, after the complainant comes to know about a so-called incident. So this was stated in a very famous case, Sarah Matthews versus Institute of Cardiovascular Diseases, 2014. Right. Coming to the facts of our case, Amit Lal versus Shantilal Soni. Right. Actually, our complainant Amit Lal has entrusted 33.139 kgs of silver. 33.139 kgs of silver to the accused person, that is Shantilal Soni, on 4/10/2009. Please remember the date. 4/10/2009, he entrusted the property. But in spite of his repeated request or whatever it is, the silver was not returned to him. That means there was breach of trust. Therefore, he approached the police. Police said it's a civil matter, it's a business matter, they don't want to interfere. Ultimately, he approached the superintendent of police. Ultimately, the case was registered. This is the fact. Right? So, the complainant approached the superintendent of police and gave a complaint on 19/7/2012, almost 2 years, 9.5 months over. Then he went to the SP and he approached and he gave a report. Then he approached SP Kach Road, Ujjain, Madhya Pradesh. Right. So, basing on the instructions of the Superintendent of Police, a case in crime number 619 by 2012 was registered under sections 406, breach of trust. Then read with 34. Oh, some other person, Shantilal Jain and another Shantilal Soni and some others would have been there. 4 accused persons are there. Right. So, the case was registered under 406. 34 means common intention, and 120B, that is a conspiracy. Right? Okay. They have investigated the case and filed the charge sheet. The charge sheet was filed on 4/12/2012. Right? So actually, the charge sheet was filed a month earlier. It was taken cognizance of the particular date. So the magistrate took cognizance of the same on 4/12/2022. Right. Here, the point is, the accused, Shantilal Soni and others, they approached the honorable, they approached the trial court, raising objection regarding the limitation, because according to Section 469, when the offence is committed on 4/10/2009, definitely the limitation will be gone on 4/10/2012. Here the charge sheet was taken on file 4/12/2012 after 2 months. So therefore, period of limitation. So the trial court did not accept. Anyway, High Court of Madhya Pradesh, yes, they have taken the other view and they have quashed the proceedings under Section 482 CRPC. How? The order of the High Court is like this. The offence took place on 4/10/2009, which is very well known to the complainant. But the police filed the charge sheet on 2022, after 3 years are over. Question. But please remember, here the important point comes. When did he report the matter? Within 3 years he reported the matter. When they filed the charge sheet, so according to 468, the charge sheet in cases where 406 means 3 years punishment, this should be filed within 3 years. Yes, it was filed. So please remember, even though the section 469 says that the offence starts from date of commencement of the offence, but the problem is it starts from date of reporting the matter. When did he report the matter? Maybe on, I think he has reported the matter on 13/11/2012. From that time onwards till 3 years. That should be taken into account. This is what is stated by the Honorable Justice Dinesh Maheshwari and Vikram Nath in the particular case. So please remember, they place reliance on Saramachu versus Institute of Cardiovascular Diseases, M.A. Cherian, Dr. Cherian case 2014, and second Somavanti versus State of Punjab 1963. So what I mean to say, please remember, the period of limitation starts from filing of the case, FIR, and that means the magistrate will be taking cognizance. So that is important, not the original date of offence. Of course, you can say in that line also, High Court is also correct. Don't be under wrong impression that High Court has totally erred. Because 469 clause 1 says from the date of offence, when it is clearly known. So both versions are correct anyway, since Supreme Court has taken up this matter and said that yes, the period of limitation starts from the date of filing the FIR, it will hold good. Right? If you know this much, it is sufficient. With this, I am concluding. Thank you very much.